Hello friends, in the previous sessions, third C when it comes to the validity of a contract or essentials of a valid contract, the first two being capacity to contract as well as consideration to contract. To start with, Section 10 of the Indian Contract Act declares free consent to be an essential requirement of valid contract. Before proceeding to the concept of free consent, we would first be discussing as to what consent is and how is it perceived under the legal provisions of Indian Contract Act. You can see on your screens, section 13 of the Act defines consent as two or more persons are said to consent when they agree upon same thing in the same sense. In our previous sessions, we have discussed that whenever we say parties are acting in consent, mutual consent, they are agreeing on the same thing in the same sense, I had introduced a Latin maxim for it to you, which I am again highlighting here to refresh your memories. The concept was consensus ad idem, that is to agree upon the same thing in the same sense. Now section 14 further provides for the concept of free consent as has been used or has been mentioned under section 10. The section 14 as such is not telling you what free consent is. Instead, it is a negative definition because it says consent is said to be free when it is not caused by firstly coercion as defined in section 15 or undue influence as defined in section 16, fraud as defined in section 17 or misrepresentation as defined in section 18 or lastly mistake subject to the provisions of sections 20, 21 and 22. Herein you can see a difference in, if you have read this provision properly on your screens, you can see a difference here that it says coercion as defined, undue influence as defined, fraud as defined, misrepresentation as defined, but for mistake it says subject to the provisions of sections 20, 21 and 22. Which means it is as such not defining what mistake is. So mistake is to be understood in its general sense only, but it will be subject to the provisions of sections 20 to 22. Consent is said to be so caused when it would not have been given but for the existence of such coercion, undue influence, fraud, misrepresentation or mistake. Which means a person, a party would not have consented otherwise to enter into a contract if the consent would not have been obtained by committing fraud, misrepresentation, coercion or undue influence or mistake. Sections 19 and 19A of the Indian Contract Act highlight that agreement is a contract voidable at option of other party whose consent was caused by coercion, fraud, misrepresentation or undue influence. Later in this session, we would be going to the provisions of section 19 and 19A of the Indian Contract Act in detail because they are delving upon the point that if the consent is obtained through fraud, coercion, misrepresentation, undue influence, that particular contract, it will become void at the option of the party whose consent has not been freely obtained, freely given. I would again try to refresh your memories. In one of our previous sessions, we had discussed as to what do we mean by the concept of or the term voidable. So when we say the contract becomes voidable at the option of the party whose consent was obtained through fraud, misrepresentation, what exactly do we mean when we say the term, when we use the term voidable? So section 2 clause I of the Indian Contract Act defines voidable and says that it basically leaves option with the party. It gives two options to the party whose consent has been is not freely given, to either continue, that is if I may say, to waive off your right to challenge that contract because your consent was not free. Instead, you choose to continue with it, it becomes a valid contract, and later on you have lost your right to challenge it by saying that your consent was not freely given, and exercise waiver or terminate the contract. So, basically first is to either continue, second is to exercise waiver or terminate terminate the contract.